nature of the public participation. The public participation report is in thousands of pages. We now want to start highlighting it. So, to answer the objection, the matter has been pleaded, the matter has been particularized, and now it is time to point out to the various pages of the public participation report for this court's consideration. In any event, my lord, the purpose of particularization is to avoid an element of ambush. The interested party, I think is the 5th and 6th, concede that the public participation reports are part of their own filings before this court. It will be new jurisprudence if a party convinces this court that he has been ambushed by his own evidence. I rest.
Mr. Rejoinder.
The reason of objection is that the pleadings, be it the petition and the affidavit, provide no particulars. A general pleading that the public participation exercise was shambolic without any particulars leaves no doubt that the petition and the affidavit provide no particulars to which the county assembly, as a body that undertook the public participation, would be able to respond. For instance, my lord, I believe it is in the further affidavit.
Yes.
At paragraph 46, the petitioner says that the flaws that are apparent in the public participation manner shall be highlighted during the instance of the hearing, during the hearing of the instance suit. As my lord, you noted before we broke, we are way past the stage of hearing. We are now at the highlighting of submissions. They ought to have provided the particulars in the pleadings so that the assembly is prepared to respond. In fact, by failing to provide the particulars, the assembly was prevented from responding to those allegations. And the assembly will be hearing for the first time today and now that a certain memoranda, a certain attendance sheet for the public participation exercise is contested. The entire, I think, 44-page document, my lord,
yes,
is the public participation exercise that happened in all 45 wards. So without saying the specific document that they impugn, the county assembly is at a loss. It is without doubt, my lord, that we will be unduly prejudiced if they provide that evidence for the first time now. It doesn't matter, and this document was prepared by the county assembly. In the Court of Appeal decision, my lord, in Mumo attempt, it is on page 24 of the interested parties, authorities. I'm going to read what in Lord was Court of Appeal held. The petition before the High Court referred to Articles 1, 2, 3, 4, 10, 19, 20, and 23 of the Constitution in its title. However, the petition provided little or no particulars as to the allegation and the manner of the alleged infringements. For example, in paragraph 2 of the petition, the first respondent averred that the appointing organs ignored concerns touching on the integrity of the applicant. No particulars were enumerated. Further, paragraph 4 of the petition alleged that the government of Kenya had overthrown the constitution, again without any particulars. Then the Court of Appeal goes on, paragraph 44, my lord. We wish to reaffirm the principle holding on this question in analytical and in general. In view of this, we find that the petition before the High Court did not meet the threshold established in that case. And the final ruling, my lord, is that it was not enough for the Superior Court, that is the High Court, to lament that the petition before it was not the epitome of precise, comprehensive, or elegant drafting without requiring remedy in the first respondent. So, my lord, if the petitioner is allowed to proceed and for the first time identify for the first time inform the respondent and the interested parties, that of which they complain for the first time now, what remedy will the county assembly have? Especially when they say, my lord, that some people did not attend. If the county assembly wanted to provide evidence, and indeed those people attended those meetings, how the county assembly will do so? If we will learn for the first time which specific meeting they are saying a particular individual did not attend, or which specific attendance sheet or minute or sheet is forged. That is the basis of our objection, my lord. Thank you.
Thank you. So, Council Mavira, so that Mavira,
Yes.
just so that I understand, it is your basis that there's an amplification. So it's not highlighting of written submissions, it's now amplification and going back to it.
Indeed, my lord, and that is what you noted in the morning, that we are way past that stage. They should have provided the particulars by the close of business.
Then, my lord, I have to respond to that specific dimension now that he introduces. Yes, because my lord calling Mr. Mavira then says he's hearing for the first time. He has mentioned that word multiple times, for the first time. First, we have shown that the petition has pleaded deficiencies in public participation. We have shown that. Secondly, we have shown that the affidavits have also deponed to deficiencies in public participation.
Yes.
I don't understand to be the case, my lord, that a party before you has an obligation to reproduce the contents of the annexures in the body of an affidavit. I do not understand that to be that when you are making the positions in the affidavit, you then must go to the annexures and reproduce the contents in the body of the affidavit.
Yes.
But more importantly, in the written submissions, which we are now highlighting, so we are not amplifying, in the written submissions, which we are now highlighting, at page 135 of volume number 9,
Yes.
at page 135 of volume number 9, you will see paragraph 225 under the theme non-existent participants in a public participation forum. Paragraph 12 refers to an affidavit, an annexure, and the pages where that allegation is. So we are here to highlight this. We are not here to amplify, we are here to highlight, to draw your attention to this content of our submissions. And therefore, my colleagues suggest that if we draw your attention to paragraph 25 as I am doing, they will be hearing of this paragraph for the first time now is a deficiency of truth. Because these are submissions duly filed and duly served upon all the parties, upon which this highlighting was predicated. So, my lord, let me say this so that we make progress. Objections are raised on admissibility of information or admissibility of material. Objections are not raised on the weight to be attached to material.
Yes.
Which is why I am finding it difficult to understand that in view of the claim we have made in the petition, which I have drawn your attention to, and in view of the depositions we have made in the further affidavit, How can this be an objection? What are they saying? That this material is not admissible? Or what is the objection? In fact, proper practice, my lord, is when a party stands and says, I object, he must state the objection. You must say, this is hearsay. That's the ground of objection. Then you specify. I am yet to understand the ground of objection. If my learned colleague's view was that the petition was incompetent, the petition itself was incompetent for want of particulars, that is not a ground of objection in submissions. That's a ground for striking out, which should have been done much earlier. And therefore, I urge that you overrule that objection and just allow Mr. Mutuma to complete his submissions. He has about just 10-20 minutes to finish his submissions.
My lord, if I may.
Yeah.
Foremost, my lord, submissions are not pleading. And to the extent that the council says they provided the particulars, paragraph 225, then he is admitting, Lord, that they did not provide the particulars of that allegation.
I didn't make a submission. I object to that line of submission. I never said particulars are paragraph 25. I alluded to the amended petition and I alluded to the affidavit of Kawira Mwangaza, the further affidavit of 27 January. Then we submitted on those allegations in the submissions.
Well, at paragraph 225 of the written submissions, my lord, that is the only attempt by the petitioner to provide the particulars of the fabricated evidence. And it is tried law, my lord, that submissions are not pleading. But for us to make progress, my lord, if the petitioner indeed limits herself to the pages she's provided in the submissions, that is page 2357, the 4 pages cited in her submissions, because those are the only pages we have said, my lord, that we prepared in advance. Even if it was not in the application, we at least had notice of where the specific particulars in support of the allegation that we found making. But for the other pages I had, Mr. Mutuma said page 2071, that was not disclosed, my lord. Not in the petition, not even in the submission that we are trying to accommodate from the lord. So in view of that, my lord, I urge you to sustain my objection.
Court, the purpose of highlighting written submissions is to give the court the benefit of the flavor, flow, and most impactful aspects of the relevant parties' written submissions. Highlighting of written submissions is and should always be distinct from a hearing. It would not be proper at the highlighting stage to amplify and connect dots of fact, evidence, or law that were not laid explicitly in the written submissions. To hold otherwise would be to allow at highlighting stage the expansion and amplification of the written submissions, which would prejudice opposing parties as they would need to have rebuttal in the form of perhaps written submissions. Paragraphs 225 to 231 under the subheading non-existent participants of the public participation fora must speak for themselves. And at highlighting, the petitioner cannot add substance or flesh out those paragraphs of the petitioner's written submissions dated 31st January 2025. This tension between what can be undertaken at hearing and what can be undertaken at highlighting can be easily resolved when one considers that it is possible and not uncommon for there to be a hearing, followed by the filing and exchange of written submissions, thereafter highlighting of written submissions. Highlighting is to explain, argue, add flavor, and better flow to written submissions, and a party cannot and should not go beyond what was contained in the written submissions in arguing their case. In view of the foregoing, the objection is sustained and the petitioner shall be limited at highlighting to the express statements and documents stated at paragraphs 225 to 231 and to the annexures and pages referenced at paragraph 225, the case law at paragraph 229, and any other similar paragraphs on in her own or other parties' written submissions.
Yes, thank you for your ruling, Your Lordship.
Yes.
I will straight away direct you to the pages where we have highlighted where we seem to have an issue with. Yes. My Lord, the public participation report before you was produced for a purpose. It was for the consumption of the court to analyze the memoranda therein and arrive at a factual determination of whether public participation indeed took place and of the quality and quantity of the public participation.
Yes.
A perusal of the said public participation report reveals that most of the memoranda therein were fabricated, concocted, and duplicated to give an impression that the people of Meru who participated in this exercise, or purportedly who participated, supported the removal of the governor. Nothing can be further from the truth.
Yes.
Your Lordship, at volume 4, page 2071,
Just a moment.
I'm not sure whether that is the volume, Your Lordship, we can...
Or the
It is,
IPs.
yes, we have extra copies. The
So I
assistant.
do have my laptop.
We have an extra copy, Your Lordship. There are two. There's another one.
Page.
That's page 2071 of volume 4.
Yes.
You will come across a photograph that is captured purporting to be an image of the people who...
Now, Council, I've just delivered extempore ruling on this aspect, sustaining an objection.
Yes.
The fifth interested party's objection is they should be able to read the written submissions, see an argument that is then being articulated, and you cannot reference a page that they have never been told.
Yes.
We have a problem with page 2071 of your volume 4 because it shows this.
And when you look at paragraph 227, appearing at page 135 of volume 9,
Yes.
the petitioner has alluded to that fact.
Yes, the petitioner has alluded to that fact. That is not in dispute. What the petitioner has not done is draw the attention of the court, but more importantly, the opposing parties, to where that paragraph is going to go. That means that at highlighting stage, remember, all of you have already filed your submission. At highlighting stage, counsel will be for the first time being informed that the specific, the particularized allegation is that this shows 1, 2, 3, 4, and it will not be safe.
Very well, Your Lordship. In that case then, because we believe the court will have an obligation to go through the entire public participation report.
Yes.
Yes.
But I understand, we understood your ruling the way you have cast it. In fact, we were happy with that ruling.
Yes.
And that's why my late colleague draws your attention to paragraph 227. But having said that, my lord,
Yes.
if you, just without putting on record, I want you to tell me the implication of this.
Yes.
If you look at volume 1A,
Volume 1.
volume 1A,
Yes.
and you go to page 339.
Yes.
And you go to the second last paragraph.
Yes.
The one starting with, I would like to take these honorable senators through the public participation vote.
Yes.
And you notice that there is specific reference to specific page numbers, to specific paragraphs of this same public participation reports. As a dispute between the petitioner in this before you and the fifth respondent that was taking place before the respondent, the fifth interested party that was taking place before the respondent. And you can see...
Councilor, go ahead a moment.
Yes.
The distinction is when you were taking the honorable senators through, you were having a hearing. So you had the opportunity at hearing to chart your ship in whichever direction you wanted. What the opposing side is saying is, once we are past the hearing stage, you cannot at highlight do the same thing that was happening in the Senate. And that's a fair point.
Yes,
Now, just so that we close this meeting, I would love to be able to have my work made easier for me by taking cross-references. But their point is very solid in law. This will be a reopening of hearing. If they were then to ask for leave to file supplementary submissions, just responding to this. And remember, your client has a sunset clause on the interim ownership. I doubt I would then be able. So please listen to the court and let's not...
Can I
Sorry, I have made a different point.
Yes.
The point I was making, if I had finished, it was as follows.
Yes.
That we have invited you to make a process review and a merit review
Yes.
of the Senate's decision. Merit review, you are asking yourself, looking at the material that was before it,
Yes.
did the Senate arrive at the correct decision?
Yes.
Why I draw attention to this is just to let you that the fact that we have drawn your attention to in the petition and in the affidavit is a public participation question, not about it.
Yes.
The manner in which the Senate's attention was drawn to it is at page 339 all the way to page 342. The manner in which the Senate's attention was drawn to it. So that what we are leaving you with is just a judicious challenge that this is the material the Senate had.
Yes.
Did it reach the correct finding on that question? That's all.
So just to put you at ease, before council also rises to the feet, I will go through each and every one of these bundles. I've already gone through most of them. I probably have a very, very good understanding of all of them. I would have loved it if there had been a cross-referencing, but that was not done. I will go through all of it. Just answer.
Mine is just to highlight the fact that with the kind of trial advocacy we have,
Yes.
when you don't have a specific date for hearing,
Yes.
and you file your pleadings, you allege and you aver to facts, and then you have your evidence in support.
Yes.
When you don't actually have an opportunity to be heard, so to speak, but you are heard through pleadings, then those pleadings need to speak. And sometimes the only opportunity to have the pleadings speak is when you're highlighting submissions. So sometimes you can't help but to cross over to the evidence, because there's never an opportunity for oral hearing as such. So I was just requesting the court to take that into cognizance, because there's a question of how was the process done and what is the merit, and it therefore means that you may have to still look at the evidence.
I would invite counsel on both sides to note that the phrase is highlight of written submissions. Highlight, we are highlighting something. And for those of us of a particular vintage, we had to literally take a highlighting pen, highlight, and then we had to do these tags, particularly at the Court of Appeal, and you could not go outside of what you had highlighted in pen. So I will look at everything that is being argued, I will cross-reference it, but for us to have a safe and orderly flow, it cannot go outside of what has been filed in the form of written submissions. I must confess, I don't think it's a very significant issue, because I will still have to determine 6 points, and I will have to explain one way or the other my merit and law review of public participation. Whether or not it has been pleaded in written submissions, even if it had not been pleaded expressly, I think odd jobs, the case of odd jobs, gives very, very good guidance. I would still have had to deal with it in the judgment. So no prejudice is being suffered by the petitioner. The objection has been sustained.
Very well, Your Lordship. Allow me then proceed to the last issue of my submission.
Yes.
That is whether the threshold for impeachment of the petitioner was met.
Yes.
Your Lordship, time and again, this court, the Court of Appeal, and the Supreme Court have had the benefit of addressing themselves on the question of threshold.
Yes.
And from all the authorities that we have relied upon, it's clear that the removal from office of a governor not be hinged on just any other misdemeanor or wrongful acts.
Yes.
Specifically, Your Lordship, Article 181 of the Constitution is very clear that there are only 4 grounds upon which a governor can be removed from office. One is gross violation of the Constitution or any other law. Not in any way to be named a violation, because a violation is a violation, whether it is of huge magnitude or less magnitude. The framers of the Constitution were very deliberate with the language. It has to be gross.
Yes.
But there are other violations of the Constitution and of the law that will not form the basis for removal of the governor by way of impeachment.
Yes.
So it is not enough then for the county assembly to just disclose a violation. They have the obligation to demonstrate the grossness of that violation.
Yes.
Throughout the pleadings at the Senate, looking at the notice of motion for impeachment, there has been no attempt to demonstrate the grossness of the violation alleged. What has been alleged is the violation, not the grossness part of it.
Yes.
The Supreme Court, Your Lordship, in the case of Sonko versus County Assembly of Nairobi City County, versus 11 and 11 others,
Yes.
had the opportunity to define what gross violation is. I will not rehash the finding. In our submission, Your Lordship,
Yes.
that as a court sitting in review of the actions of a quasi-judicial body in your supervisory jurisdiction,
Yes.
you ought to go back to the charges and to the evidence and satisfy yourself that indeed the threshold was met. When you try to do that, Your Lordship, it will surprise you. But the removal of the governor was based on employment disputes, which by whatever definition cannot qualify as gross violation. In any case, Your Lordship, closely related to that issue,
Yes.
is that employment disputes in question for which the governor was impeached were matters that were active before the proper forum, that is the Employment and Labor Relations Court.
Yes.
That court is given the mandate by the Constitution and statutes to deal with employment disputes.
Yes.
It would then mean that the provisions of Article 35 on the right to political participation are being violated. I'm sorry, that is 4 of the Constitution, where the people of Meru make their choice in respect of who should be their governor. And all you need to do to overturn that will is just to find any administrative dispute and accuse the governor of it and seek to overturn that.
So, Council, when I undertook a preliminary reading of the written submissions,
Yes.
please turn to paragraph 202 of your submissions dated 31st January 2025.
I am there, Your Lordship, yes.
So those are the four. Which ones were, to the petitioner's mind, sub judice and pending before the ELC? Of those?
Very well, Your Lordship. The issue of paragraph B.
Yes.
Paying Christus Manyara, a public communication officer in the office of the governor, that was an issue that was under this. We have taken time. We have gone an extra mile, Your Lordship,
Yes.
to create a table that demonstrates, and that is to be found at page 40 of our volume 1. Page 40 of volume 1.
Yes.
Count 1, Your Lordship, was on acts of office. The particulars was that the governor was accused of legally revoking the appointment of CPA Virginia Kawera Moretti as a CEO of Meru County Public Service Board. This is a matter, Your Lordship, an employment dispute that at the time of hearing at the Senate was alive at Meru Employment and Labor Relations Court, case number E002 of 2024. The parties, Virginia Kawera Moretti versus the governor of Meru County. It cannot then be in dispute, Your Lordship, that this cannot a gross violation of the Constitution. It is an employment and labor relations dispute. And that's why it was forwarded for arbitration and determination to the right forum.
Yes.
We are constrained to speak up because we're trying to access those volumes the way Council is referencing them. And we cannot see them either on the CTS. When we look at volume 1, volume 2, or volume 3, we cannot see it there. So we are not able to follow. And remember that the petitioner never served us these documents.
So there's an amended petition. If you
If I
get
may-
page 12 of the amended petition, that's where you will find that table.
But that's not the problem. The problem is if they keep referring to volume this, volume that, you not have that. We can't follow.
Your Lordship, if I may explain, if I may explain.
This is not a big issue. So, Council Mutuma, when you say volume 1,
Yes.
then say what is
Correct.
the document and the page number.
I'm referring to the amended, the petitioner's supplementary affidavit at page 12. Amended petition.
Four grounds, yet in your other documents you have others that have been mentioned. So, for example, four grounds, yet in your other documents you have others that have been mentioned. So, for example, count 2 and 3 that is referenced under page 12.
I get your point, Your Lordship. Paragraph 2 of 2 is specifically talking about the ground on abuse of office. So under abuse of office, we had 4 links.
Yes.
So the ground itself is abuse of office. But underneath, you would, if you may, Your Lordship, count 1 to 4. Under that, one charge.
So that is only on abuse of office.
Correct.
Misconduct.
Correct, Your
It's not
Lordship.
on the rest.
Yes. Your Lordship, back at page 12.
Follow if I may.
Yes.
I think the point is at page 12, count 2, page 12 of the amended petition. What the petitioner says is alleged murder is a misrepresentation. Because the allegation is as per what is on page 2. Paying term fees as Mandela. It is not alleged murder. That is a deliberate misrepresentation of the impeachment allegation by the petition.
My Lord, I must now make it clear that it appears to me that there is an undisclosed strategy by the respondents and the supporting interested parties to disrupt the flow of thought of the petition as much as possible with a view to a collateral advantage. We are making statements, my Lord. Each one of us has a benefit of something called train of thought. And if you look at the number of objections we have had today, it must now begin getting curious. My learned colleagues have a chance to reply a whole day on Monday to tell this court where misrepresentations are, where half-truths are, where falsehoods are. Please allow Mr. Mutuma to make out his case the best way he can. It cannot be fair to the petition for us to face this barrage of objections in the middle. There's no single sentence Mr. Mutuma makes that is allowed to complete. If Mr. Mutuma has made a statement that is factually incorrect in the face of the charges, my colleagues will refer to the charges and respond. It's only fair.
Thank you. Thank you, Your Lordship. Your Lordship, once again, just to demonstrate the fact that the charges as against the governor were nothing more than administrative issues that could have been and indeed were resolved in other forums. I'll move on to the next, rather the second count, the second limb of count 1, that is illegally dismissing Dr. Ndoiti, CEO County Revenue Board, Paul Mwaki, CEO Liquor Board, Kenneth Kimathi Mbaye, Managing Director Microfinance Corporation, and Joseph Kidure.
Council, we covered this earlier. I
Yes.
recorded this
Yes.
earlier.
Yes.
So perhaps we can skip that.
Yes. So my point on this issue, Your Lordship, is that the framers of the Constitution did not envisage a situation where violations capable of being dispensed with, determined in a different forum, provided for by the Constitution and the law, would find their way as a ground for impeachment of a governor. Because they are not us. Violations, yes, and we are not admitting that the governor was liable, but there were forums to address those issues. We have demonstrated it, that those disputes, administrative in nature, employment disputes, were in other forums capable of addressing them. They cannot therefore then fit within the meaning of gross violation under Article 181.
Yes.
Not by the definition of the Supreme Court. Again, Your Lordship, the Supreme Court in the Supra case was very clear that there has to be a nexus between the violation complained of and the acts of the petitioner.
Yes.
You will go through all the charges against the governor, Your Lordship, and you will find that to a larger extent, not 100%, the act complained of were of that parties and not those of the governor.
Yes.
That be the case, Your Lordship, then it cannot be argued that the threshold under Article 181 of the Constitution was met.
The Bora case decision on nexus, can it also apply to command responsibility? We're saying the chief executive officer of a county has a command obligation to ensure that even if he or she is not the one who directly did something, they must exercise supervision and control to a required extent, failure to which in their life equally liable.
Indeed, Your Lordship, one might want to approach it that way. But evidence must be established that the petitioner or the governor, in that case, willfully, number one, was aware of the violation by a party and failed to take action, having been required by law to do it. At the Senate, Your Lordship,
Yes.
we want to demonstrate that even where resolutions were passed against certain individuals who are not the governor,
Yes.
there was no evidence to indicate that that was brought to the attention of the governor, requiring her to take action.
Yes.
So then that means that those action lay squarely with the people that had perpetrated.
Yes.
I have no time, Your Lordship, to go through each and every count,
Yes.
but I humbly request you to go through the motion as found at page 2144 of volume 6.
Yes.
All the way to the end of the motion. You will have no doubt in your mind, Your Lordship, that the charges against the governor could not meet the threshold of gross violation. In conclusion, Your Lordship, I want to say that the governor has established a case for the following. One is that Article 181 of the Constitution
Just a moment. Yes.
as read together with Section 33, and this time I'm referring to Section 33 as a whole, not 33(8),
Yes.
that any person seeking to invoke those two provisions must do so within the authority of the Constitution and the law.
Yes.
It has been established without a shadow of doubt that the respondents, fourth, fifth, and sixth respondents, interested parties rather, did not have the authority of the law to proceed with impeachment. For the simple reason that they had been prohibited expressly from proceeding with the impeachment process by a valid court order. As we speak, Your Lordship, the County Assembly of Meru,
Yes.
the Speaker of County Assembly of Meru, mover of the motion, one is Paul Akinya, are convicts. They have been found guilty.
The Speaker of the County Assembly.
The mover of the motion, one is Paul Akinya, and the County Assembly of Meru
Yes.
are convicts. a court of competent jurisdiction has sentenced them to a period of 6 months imprisonment. I am surprised to see that they are hovering around. What then needs to be done, Your Lordship, is for first to purge the contempt, because very well, I will just talk about that. I will talk about the fact that they are convicts.
Yes.
On the second issue, Your Lordship, the petitioner has been able to establish that her right to fair hearing has been, one, threatened to be violated by the County Assembly of Meru,
Yes.
and indeed violated by the respondent in this matter by failing the impartiality and independence tests as expected under Article 50 of the Constitution.
Yes.
By way of summary, Your Lordship, is that a decision was made to remove the petitioner before the actual voting took place, and indeed that decision was communicated. There is no other indication of lack of impartiality, lack of independence, and failing to uphold the right to presumption of innocence.
Yes.
That action alone is enough to demonstrate that the Senate was not only biased, but very much partial.
Yes.
Related to that, Your Lordship, is that we have been able to demonstrate
Yes.
that the County Assembly of Meru, together with the Senate, exploited an inconsistent provision of the law, that is section 33(8), and went against the rule of against the jeopardy. That is a violation of right to fair hearing.
Is the proper term then inconsistent? Because I read at length where you were stating that it's unconstitutional. Isn't that better word?
Yes, Your Lordship, inconsistent to that extent, therefore it has to be declared.
Consistent with the Constitution.
Yes, it is inconsistent with the Constitution, therefore must be declared unconstitutional.
Yes.
We invite the court to invoke its powers under Article 165 and declare that section as unconstitutional to prevent its abuse. Your Lordship, as you go through the public participation report, you will discover that there was no compliance with the principles of Article 10 of the Constitution. What has been presented to you is shambolic and a mockery of the process. Having done that, Your Lordship, unless you do not anything, the petitioner rests the case. Thank you so much, Your Lordship.
Thank you. So we have interested parties in support. Which interested parties are supporting the petition, and how much time would you need to highlight written submissions without repeating ground that was covered by the petitioner?
My apologies. We didn't put on record Mr. Desire Njamwea for the 7th interest party.
No, he did. Before we took the break,
Okay.
He did.
Thank you. Okay.
The first interested party?
Thank you, my lord.
Yes. How much time would you need? Which is confirmed.
I had requested for 30. I'm not too sure with the developments and to avoid regurgitating what has already been stated by the petitioner.
Yes.
I can do a bit less than that.
You can do a lot less than that. Can we give you 10 minutes?
I'll endeavor to stick within the 10 minutes.
I'll stop writing
not-
at 10.
It's okay, my lord. I will try as much. My lord, we...
Just a moment. Second IP, probably you also in support.
My lord, yes, we are in support of the petition.
How much time?
15 minutes.
10 as well. That takes us to the 7th. 10 as well. You had said 3 before the break. Maybe the 7 extra. Let me give you the 10. So that's 10, 10, 10. So it's a combined 30 minutes. If one interested party is less than that, I'll just add it to the next. So we'll start with the first interested party.
Thank you, my lord. On the part of the first interested party, my lord, we wish to state that we file a reply affidavit dated and filed on 14th January 2025 in response to the petition, rather amended petition dated 23rd December 2024.
Yes.
Well, we also filed our written submissions dated 4th February 2025,
Yes.
as well as a list of authorities dated 4th February 2025 and filed on even dates, my lord,
Yes.
in support of the amended petition dated 23rd December 2024.
Yes.
I wish to point out to the court that we associate fully with the submissions and the supplementary submissions filed and highlighted by the petitioner in this case.
Yes.
Well, the first interested party is established pursuant to the provisions of Section 19 of the Intergovernmental Relations Act, my lord.
Yes.
And the mandate of the first interested party, my lord,
Yes.
is then provided under the provisions of Section 20 of the said Act.
Yes.
The first interested party then coordinates the 47 county governments on matters of common interest with regards to the implementation of the resolution.
Yes.
We have then, the first interested party has then crystallized 5 issues for determination or for consideration by this Honorable Court in support of the petition. The first issue, and I'll read them in chronology, my lord,
Yes.
is whether the impeachment proceedings against the petitioner met the constitutional threshold as provided under Article 181 of the Constitution,
Yes.
as read together with Section 33 of the County Governments Act. Secondly, my lord, is whether the actions of the fifth interested party, that is the County Assembly of Meru,
Yes.
amounts to an abuse of the impeachment process as an oversight and accountability tool.
Yes.
Third question, my lord, is whether the impeachment process was procedurally flawed in violation of the principles of natural justice
Yes.
as laid out under the provisions of Article 47 as read together with Article 50 of the Constitution.
Yes.
The fourth issue concerns itself with whether Section 33, subsection 8 of the County Government Act is unconstitutional, allowing repeated impeachment attempts over similar facts tried and tested by the relevant bodies. Finally, is whether it is in the public interest to allow the petition filed by the petitioner, my lord. My lord, as you permit me to venture into the first point.
You have just about 5 minutes.
Yes.
So perhaps I can guide. Your fifth limb is the one that, and I've had the benefit of already reading the submissions, is the one that perhaps has not been extensively canvassed by the petitioners. Perhaps more accurately, it is differently argued. So perhaps that is what we should highlight. Any strong points on that?
On the fifth point, my lord?
Yes, whether it is in the public interest to allow the amendment petition.
Okay. Thank you, my lord. I will just gloss over some of the issues to avoid regurgitating what has been said by my language colleagues, Mr. Mutuma and Mr. Ongoye. My lord, it will suffice to state that presently there is no legislation that deals with the question of impeachment. There is no standalone legislation that deals with the question of impeachment.
Yes.
My lord, this is so despite the specific provision of the Constitution, specifically Article 1, Sub-Article 2, which states specifically that Parliament shall enact legislation providing for the procedure of removal of a county governor on any of the grounds specified under Subclause 1. My lord, the County Governments Act has donated a section, just a simple section, as one section that deals with this question. The constitutional provision states that there has to be a standalone legislation to deal with that question, my lord.
Yes.
My lord, where does this leave us? This leaves the determination of impeachment processes to the jurisdiction, to the jurisprudence, my lord, sorry about that.
Yes.
That has been set out in previous impeachment proceedings, my lord.
Yes.
We are then guided by the judicial authorities. And the leading one, my lord, being the case of Martin Wambora and 3 others versus the Speaker of the Senate, Civil Appeal number 21 of 2014, my lord.
Yes.
In this particular case, my lord, the court then emphasized that there is a need to maintain a high threshold for the removal of Governor, my lord. It also went ahead to lay out the standard of proof which is then required for the removal of a Governor, my lord, which the court states is above a balance of probability. it goes ahead to say that there has to be a nexus between the governor and the alleged gross violation of the Constitution.
If you look at the petitioner's written submissions,
Yes.
their first set, the ones for 31st January 2025, they canvass that case and those names from paragraph 189 to paragraph 201. What they have not done in one conject, unlike in your petitions, did not address the question of expressing the public interest. And that is why I was guiding you to that.
Yes.
So that you, in the remaining 4 minutes, get to, you have not read Wambora, you all
Yes.
know the limits for it. But I was quite, I wanted you to flesh out your thinking on public interest,
Yes, my lord.
how it applies to it.
Thank you, my lord. I will then, but the point that I wanted to lay out, my lord,
Yes.
if you look at the charges vis-a-vis what has been set out under 181, there is use of the word gross violation. There is also use of the word abuse of office or gross misconduct, my lord. And the point that I want to hammer home probably is that not any other offense, my lord, will then qualify within those parameters, my lord. There was a deliberate use of the word gross in 2 of the grounds that have been set out under Article 181, which has then now been interpreted by the Honorable Court in the Wambora as well as the other petitions before you, my lord. My lord, in light of the guidance that you have given, I will then go into the issue of the public interest in line with the guidance you've given.
Yes.
We will hope that the court will be able to peruse the rest of the submissions as filed for lack of.
Yes. I already have.
Thank you, my lord. My lord, we then go into the question of whether it is in the public interest to allow the petition, my lord. My lord, the petitioner is the first governor, my lord, in the history of devolution since its inception, to face 5 charges, 5 impeachment attempts, my lord. We have been able to set out the various impeachment process that she has been able to go through in our affidavit.
Yes.
With the first one being, I think, 57 days after the inauguration, my lord. This impeachment came in at a time when the governor had not even set up her county executive, my lord. Which then means that she had not been given ample time or rather sufficient time to be able to put out the governance structures so that she can be able to implement the manifesto that she had for the people of Maryland.
Yes.
The repeated impeachment attempts, as outlined in the proceedings, my lord, we submit, have far-reaching implications, my lord, on the governance of the county government, my lord. My lord, governors as well as other state officers come into office on the basis of universal suffrage, my lord. They are elected by a majority. It defeats public interest, my lord, for any state and re-elected into office to be subjected to continued and repeated, as has been demonstrated by the petitioner through her counsel,
Yes.
impeachment attempts, my lord. What then is the public interest, my lord? that the county government is always in a mood, or rather a mode of an impeachment or a removal of the elected leader from office. At what point does the governor duly elected then settle in to be able even to implement her policies? My Lord, with the provisions of section 33.8 as has been highlighted, my Lord, also similarly in our submissions, it then gives the latitude of the assembly to then reintroduce further impeachment attempts. And my Lord, because I've had the benefit of the sight of the videos that were just about to be played, my Lord, I am almost certain that if this impeachment process was not approved by the Senate, then probably might be facing another impeachment process, my Lord. The trajectory that has been demonstrated by the County Assembly of Meru, and this is the first, has then been, if the Senate does not confirm the charges, they then just go back and reintroduce the motion. We submit that then stabilizes the operations and the governance of the county, my Lord.
Yes, on public interest,
yes,
aside from a finding that section 33 subsection 8 is constitutional, does the first interested party have any other view as of possible remedy for what you have outlined under that law?
My Lord, we submit that that section is the core of some of these issues, my Lord. If you look at the removal processes of other state officers, my Lord, like for instance for members of parliament, are able to enact, the benefit they have is that they are makers of laws, unlike the governor who is in the executive, Lord. They've been able to chart out the Elections Act, which has certain cushions, my Lord, with regards to their removal by way of recall, my Lord. It has timelines within which the recall cannot be undertaken. You have to undergo a whole court process, and as such, they have shielded and cushioned themselves from this recall procedure that is then laid out in court. Probably that's the reason why we've not had any member, both of the National Assembly or even members of county assemblies, recalled, because they have legislated on parameters that have cushioned them.
So about 1 minute.
Now, just to wind up on this particular question, these state officers of the capacity of governors are elected for a specific period of time, my Lord, to deliver service, my Lord. If we then have a trajectory of an assembly going against to institute impeachment proceedings within those timelines that we have seen the County Assembly of Meru institute, my Lord, we will then have a scenario where there are constant interruptions to the governance. I have attended these proceedings, and the governor has been attending these proceedings since we commenced, even mentions. So a whole day is then spent in these corridors. Countless numbers of times are spent within the corridors of the Senate and the Assembly, my Lord. At what point will the county then allow the governor to settle, to set up, and to implement, my Lord?
Your time expired, but I will repeat the question I posed to you.
Yes.
Other than a finding of an constitutionality for section 33, subsection 8. What else could the High Court do? Because you have, under public interest,
Yes.
fleshed out a problem. You've argued it at quite some length, but your solution is only 33A, which may not.
My Lord, the solution, just to clarify to the court, is probably what I commenced with. Despite Article 181, Sub-Article 2, laying out specifically of our need of a legislation to take care of issues of impeachment, we have not seen any such legislation. Also, my Lord, just to guide...
I have to say that for the record. What is the first interested parties opposed for the problem that it views?
The problem can be, because this is a governance issue, my Lord, the problem can be through enactment of a legislation that then substantively defines these parameters, because this has been left to the various judgments. It will then lay out processes in great detail.
Yes.
It may also have regulations, my Lord.
Yes.
To be in.
Right, thank you.
Thank you.
Yes.
To be in.
Right, thank you.
And I just wish to end by saying that it is in the interest of justice and in public interest that we allow the petition as amended. I want to thank you for the time that you've given, Lord.
Thank you. Yes, ma'am.
Thank you, my Lord. I think my name and details were taken for the record.
Yes, you miss quite well known as well.
It's not aware. Thank you very much. Right. I'm here on behalf of the Federation of Women Lawyers. The reason that we joined
Just a
this.
moment. I was writing one. Yes.
I'm here on behalf of the Federation of Women Lawyers, and we thank this court for enjoining FIDA to this matter, because one of the key components and assignments FIDA since establishment in the 90s is to advocate for women's rights, and that means all women from all walks of life, shape sizes, including the governor for Meru County. So the work you're doing today, Honorable Judge, is a very serious assignment for the women of Kenya, all the well-meaning women of Kenya, including myself, because I have plans to be a governor not long from today. And my Lord, that is why the impeachment of Governor Kawira Gaza must be quashed. This is because since 1963, that is 12 December 1963, what the people of Meru County Assembly have done to the governor has been the greatest affront to realization of women's political rights. In Kenya, there has been none worse than that, my Lord. Perhaps, and because I had counsel refer to Anarita Karimi, I would like to say that we can only compare what she's going through to what that lady Anarita Karimi went through. She was not only bundled out of parliament, but she was also jailed in a very discriminatory manner. And I wish to say that there are various similarities between these two women. One of which is that they are both from Meru community. So what I would like this court to do this afternoon is also focus on this community of Ameru and how it is that they view women. Because since 1975, my Lord, I see you thinking.
to a special hearing cast
Just a moment. I don't think there's a safe way for me to record that at all. It may not do the proud Ameru community service for me to record that.
I will use a different way. I just want to say both women were from the Meru society, and since 1975, when Anarita was elected, the second other elected woman from the community is Honorable Kawira Mwangaza to that level. There has been no other parliamentary elected woman in a contested all-gender election since 1975. Why am I saying this? It's because I don't believe it will be possible to give a fair, full and final determination of this matter without looking at the social and cultural aspects of the society.
Now, there's quite a lot of case law on the ambit of an interest party and what they can do. That submission strays quite far from what the petitioner has stated. In essence, it creates its own petition and then argues against it. There has been no allegation by the petitioner of gender discrimination.
My Lord, I have to say that we are here in support of the amended petition filed in December last year.
Yes.
And when you look at
does not contain that gender discrimination aspect, an interested party then cannot create a substantive ground, because gender discrimination is prohibited by the Constitution. I could determine the petition on that ground and that ground alone. So an interested party cannot create.
So there's the aspect of equality under the law in the petition.
Yes.
And lack of there having been equality under the law with respect to.
So let's go to the amended petition dated 23rd December 2024. So one of the things that we do with petitions is we begin by stating, and normally it's paragraph C, the constitutional foundations of the petition. So in paragraph 14, that's page 4 of the amended petition, the petitioner says Article 27 provides for equality and freedom from discrimination, and particularly that every person has rights to equal protection and equal benefit of the law. Further, the state shall not discriminate directly or indirectly against any person on any ground. However, when they go into the contraventions and violations, they argue that very, very differently from the route that the interested party appears to be going down. The equal protection argument there was substantiated in terms of a process, not substantive discrimination. Perhaps Councillor Ngoya or Councillor Tuma?
Sorry.
So that we just know, was there either discrimination, ethnicity discrimination angle?
Yes, my Lord, if you look at volume number 1, that is the supporting affidavit of Kawira Mwangaza, sworn on 23rd December 2024.
Yes, there's paragraph 4.
Paragraph 4, yes.
Yes, paragraph 4 the same.
Yes.
I'm not disputing that there's a paragraph 4 of the same in the supporting affidavit. I am in the petition stage, and I hope now we can all agree I've read all your documents. I know them backwards and forwards. What I'm asking is, in the petition, because you cannot also create a substantive ground in the supporting affidavit. In the petition, as what is said at paragraphs 4, 5, 6, 7, 8, and then a little bit on 9, is that stated in the petition, in the amended petition, in terms of the region, the relentless ganging up in terms of gender or ethnicity?
Let me just say this and leave it to the court. One,
Yes.
the petitioner has pleaded discrimination. Number two, the petitioner has made reference to her gender at paragraph 4 as we have alluded to it. And number 5, when the second interested party made a request to join here, they disclose what the scope of their identifiable stake in the matter is, and with that gender dimension. I will leave it to the court to see how to guide them from that onward. But I guess when my learned colleague, Ms. Lumalas, came to the matter, she made it clear from the very outset that this is her stake in this matter.
Councillor Lumalas, your time has been off. I've expressed my reservations, but I will allow you to proceed with that argument.
Thank you very much.
Yes.
Actually, when you look at our application for joinder notice of motion, this very issue is what was the main reason why we joined. And the limb of her political rights, violation and discrimination.
Yes.
When you look at the petition, they have pleaded Article 38.
Yes.
And I'd like to refer this court to Article 38 3C of the Constitution.
Yes.
So that when Honorable Kawira went on election and won the election,
Yes.
she has a duty to enjoy that seat, or a right to enjoy that seat. And you as the court, my lord, you come in at Article 38 3C.
Yes.
That since she has a right to be a candidate for public office, to belong to any political party of her choice, then according to this article, she has a right not only to be elected but to hold that office.
Yes.
Yes. Now what we are saying is that there's been a deliberate scheme to ensure that she does not hold that office. We thank God that irrespective, because our submission is that that community is a very patriarchal community. We submit that. It is our submission based on evidence on record. We also wish to
Council, if you have an issue with anything that Council has said in submissions, please don't articulate it too loud. I'm not saying you can't articulate it, but not so too loud. Yes, Council, please.
Thank you very much. I've been interrupted a lot, my lord. But that shows you that I am onto something. Because in the morning there was the question of, because my lord, I've talked about 5 impeachment motions. And look at the dates of the impeachment motions. Barely 2 months after she was in office, November 2022, the first impeachment motion. Second impeachment motion, same year of election, 30th December 2022.
Let me have the first date, please.
21st November 2022. 30th December 2022. This is election year. 17th October 2023. 17th July 2024 and 31st July 2024. My lord, in the morning when the question of what the Meru court meant by saying, using the word that there's a possibility of some gamers behind this scheme, I had an opportunity to review the videos before I came to court, and I'd like to refer the court to some of the video recordings which will support our position. KMV 12, KMV 15, KMV 17 and 11. And when you look at these videos, you will understand, and you are there on the online platform when you are requesting to join as interested parties. You saw the level of abuse.
Yeah.
And it is typical of a patriarchal society to get a woman to fight another woman, my lord. This morning we saw one lady by the name Zipporah, who is a 6th interested party, who, having no faith in her counsel, wanted to stand up and address you. And I'll tell you why. The reason is when you look at volume 1 of the petition, volume 1, what is your volume?
Your Lordship, I will request that counsel provides evidence that my client has not found.
Counsel.
What evidence was
Just a moment. Counsel. You know, we don't need to make everything urgent. It's not an issue. What you can perhaps consider is the court has already said it has reservations. That is already very, very simple. But I have said I will record, but I have said there are reservations as to how this is being articulated. Yes, counsel, please proceed.
As I just want to let the court look at volume 1A.
Sorry, you left me at a patriarchal society,
The men,
a woman,
yes, to fight another and hurt another woman. And one such woman stood here this morning. Her name is Zipporah Kenya. She's a interested party, sixth interested party. And unfortunately, this happens a lot among the women folk. But you can see she wants to take the glory out of...
No, that is not.
I'm actually referring, my lord, I'm referring to her own words.
Yes.
When you look
I
at...
understand that is what was stated in the six interested parties affidavit. The challenge is if you would reference that specific argument within your written submissions, what paragraph would I be able to look at?
My lord is, I'll proceed.
It's a big challenge you've been having, and
It's okay.
I recognize,
You know, I
recognize what you were saying earlier, and perhaps there is need for us to do these sorts of cases differently. Perhaps we should have the hearings, we should have our standalone hearing,
Yes.
and then
Submissions.
of written submissions. I will.
Thank you. I only just brought it because of an interruption of the court session, but then I'll leave it to the court. Now, so having moving to conclusion, so the impeachment of Honorable Kawira was not lawful at all. When you look at the process in Parliament, you see the need to rush the proceedings. Not only in the manner in which the gazettement happened, but also for me personally, and this is what we've taken out in our submissions. Having known parliamentary proceedings, I have 8 years in parliamentary work, there was no need not give the senators a right to submit. And their complaint is on record, and that is one of the issues we have pleaded. There's always an opportunity to let the hearing proceed to the next day. That is one. Number two, Honorable Kawira, and we all saw that, was not given an opportunity. I don't know if you're recording this.
Yes, I am.
She was not actually given an opportunity to respond after a barrage of submissions by a section of senators. When she asked for an opportunity to respond, the speaker informed her that time is up. So whose time is up? And are those considerations for fair hearing, my lord? When you look at the Constitution and what it guarantees with respect to fair hearing, you will find that that kind of hearing is devoid of chaos. Just for the chaos which have been admitted in the Hansard alone and the violence, that impeachment has to be voided. And the fact that she was not given an opportunity to respond in oral submissions, that is also a violation of due process to be had. It has to be quashed. So what are we asking? We are asking you to review and give appropriate orders that will enable women in political offices, irrespective of the environment that they operate in. And we have demonstrated that both Kawira Mwangaza and Anarita before her operate in a very patriarchal, male-dominated environment. And I have an article on patriarchy which unfortunately I didn't share, but I'm happy to distribute. That community is still heavily dominated by the decisions of the Njurincheke. And they have already declared who the spokesperson is. They have installed the deputy governor as a leader. That's all in the videos. I saw that, my lord. And I hope you will see that and the implication of this. So that when you're issuing the orders, you will declare. We have requested in our submissions that...
I wish to get to what Council just said. It is misleading. And there is a video in the videos that were submitted of the deputy governor being brought to
I will qualify it this way. It's not installed, but oaths.
Just a moment. I was constrained when Councillor Ongoya raised this point, but now I will have to formally say this. The objections, aside from one, were not of the nature of objections. Councillor Ongoya said it is a scheme to deliberately take those in support of the petition off their train of thought. And I didn't say anything, because that's a very high threshold that requires. But it has been. It has been. Not everything needs to be an objection. It's a statement that has been made in the written submissions. I have already expressed I have reservations as to whether there's a nexus between the amended petition and missions, but I've had enough to continue. So let me state this plainly. The next time anyone in opposition of the petition rises, it should be a cogent objection or no. Not an argument that this is not relevant, that you will have in your time. Am I understood?
Yes, I just wish to really plead with the court to declare Section 33(8) of the County Governments Act unconstitutional, as already pleaded, to issue an injunction against further discrimination and public abuse and ridicule of Honorable Mwangaza, which is why we are also here, because there was a lot of abuse online, and we would like that, once these orders are out, that the people of Meru are managed and they accept their governor until the 5 years are over. I thank you, my lord, and we look forward to upholding of the rule of law in this matter. Thank you.
Thank you. So for the avoidance of doubt, everything has been submitted by counsel for the second interested party has been recorded, is safe, and it shall be considered in the judgment and to be treated in the same manner as the other submissions. Seventh interested party.
Much obliged. Thank you.
Thank you, my lord.
You promised me 6 minutes.
Yes, I promised you 6 minutes, and I try my best to live to that. My lord, I represent the National Gender and Equality Commission.
Yes.
And the commission comes in support of the petition. And before I proceed, I'd like to state for the Lord, I'm a he for she. Thank you, my lord. I'm a he for she. I'm a he for she. I'm a champion of gender rights. Thank you, my lord. My lord, allow me to go straight to the ground as to whether the impeachment proceedings violated the petitioner's rights of equal protection and benefit of the law. Without going much into the details, because the petitioner alluded to this. My lord, what is the law?
Just a moment, yes.
On a point of law, as you have corrected the evidence.
Yes.
The second interested is counsel states that he rises to support the petition.
Yes.
And in doing so, my lord, he has filed before this honorable court a replying affidavit for that petition.
Yes.
Signed by a person by the name Q.
Yes.
My lord, we seek to draw to your attention that the said affidavit is sworn Anne Raso,
Yes.
an advocate of the 105.
One and
Anne Raso, R-A-S-O-W-O.
so just say the name again.
Anne Raso,
Yes.
R-A-S-O-W-O.
Yes. Yes. So
Our number is P105.
yes.
Stroke 10007
Yes.
stroke 13.
Yes.
My Lord, the said Anne works at the National Gender Equality Commission, and therefore the affidavit as she has filed before the court, as you have just discovered,
Yes.
is incurably defective, and it must be struck out of the record of this honorable court. In addition, my Lord, we know that the same Anne Raso, despite commissioning the said affidavit and having being an employee of National Gender and Equality Commission, and having commissioned the said affidavit this year, she does not have a practicing certificate. My Lord, those two issues go to the root of the affidavit and the case that the seven interested tries to make before the Honorable Court, in the sense that the affidavit violates Section 4.1 and 2 of the Oaths and Statutory Declarations Act and Section 24.2 of the Act. It follows, therefore, that the submissions that Council wants to make before this Honorable Court have no basis. The seven interested parties has no legs to stand on, my Lord. It must fall flat on its feet.
Yes. Yes, you can have a rejoinder.
Thank you, my Lord.
Response.
The Commissioner, Anne Raso, is a Commissioner for Oaths. As of 15th January, she was an active legal practitioner with a valid practicing certificate. It is that anything to question about practicing certificate can only be questioned after 31st of January 2025. Thank you, my Lord.
Rejoinder.
My Lord, Section 24.2 of the Advocates Act states that our practicing certificate is valid from 1st of January to 31st of December. The only time that the practicing certificate is valid for the next first month of the year is when that advocate has made an application to renew that PC. The PC, my Lord, as we are looking right now, is still active. It means she has not renewed her PC.
Yes.
And my Lord, we understand that the court is tech-savvy. It's a decision that the court can easily make by checking the advocate's search engine to establish whether the Anne Raso is active or not. It will also demonstrate, my Lord, where that person is in manual works.
You know, without making a new line of argument, is also saying that this advocate was not licensed to practice for the year 2024. I don't hear him to be saying that. He's saying as at 15th January 2025, this advocate was not licensed. Is there any one of us who have a license out as at 15th of January 2025? I'm posing a question, my Lord. I can't respond it like that. My colleagues know that their clients can do that and they will understand. But for them to do that, even they know they're out of order. They can't do that. Isn't there sufficient practice this court can take judicial notice of that every advocate in this country is allowed to practice up to and including the end of January of the succeeding year for the renewal of the license? So I think that's a matter that we ought not to make a big issue when we concede that this advocate's license in 2024 which I can see clearly on the portal that she was licensed.
There are two arguments that have been made. I'll deal with the second one. Even when I had to take out a PC, it would take some time. And it wasn't always, even in our law firm, there were multiple advocates. Some of us would be active before the rest. And we paid under the same check at the same time. So that is not determinative of the probity and admissibility of the impugned reply affidavit. The other link, the first link, is the question whether an advocate of the High Court internal to an organization can commission a affidavit is the more cogent and persuasive one. Is it in dispute that the Commissioner for Oaths works within the 7th Interested Party?
My lord, it is not in dispute.
Who has a hard copy of it? What counsel should have also pointed out, which I have confirmed, is the Commissioner for Oaths address is the same, postal address is the same address as that of the 7th Interested Party. There's a reason that even when we're in our law firms, we have to walk outside and ask a colleague to come over, or we take the deponents to their chambers for them to commission. We are not allowed to commission internally, so that aspect is sustained. Now the challenge will be, have you filed written submissions? I need to state it for the record.
Yes, my lord, we have filed written submission.
If you lose your replying affidavit, then you will lose your written submissions as well, because your written submissions went into what has been deponed to, particularly tying a nexus with paragraph, tying a nexus with paragraph 4 and 5 of the petitioner's supporting affidavit. So, quote, an objection has been raised to the 7th Interested Parties replying affidavit dated 15th January 2025 on the principal ground that it was commissioned by an advocate in the employ of the 7th Interested Party, thus in contravention of the oaths and statutory declarations. Counsel for the 7th Interested Party has conceded that this is factually correct in terms of employment. Thus, find that impugned replying affidavit was properly commissioned, thus was fatally and incurably effective. Today being highlighting of written submissions, the court had already respective parties' written submissions. In that regard, I note that the averment of the now struck out decline affidavit filed by the 7th IP permeates the entire length and breadth of their written submissions. Consequently, the 7th IP's written submissions are equally, fatally defective and cannot be relied upon as the substratum does not exist. The 7th interested parties submissions thus also struck out. However, in the interest of justice and noting that the 7th interested party has participated diligently in these proceedings, they shall be allowed 5 minutes to submit, but limited to the petitioners, first interested party, and second interested parties written submissions, 21st February 2025. So I will limit you only to those 3 parties, 5 minutes, please.
Thank you, my lord. Now, in terms of whether the petitioner's right to equal protection and equal protection and benefit of the law was violated, my lord, we proceed to ask this question: what is the law, or what was the law in the context of these impeachment proceedings? From a legislative perspective, the law are, from a legislative perspective, the laws are acts of parliament, statutes, but from a judicial perspective, the law is or includes rules of court, court orders, and perhaps to mention in Article 23 includes all those reliefs. Once granted, they become the law, or once issued. In this particular impeachment proceedings, my lord,
Yes.
at the county assembly, there was a conservatory order, a law that had been issued in favor of the petitioner.
Yes.
The violation of that law put the petitioner in an equal status where she could enjoy the protection of the law that she was seeking. On the other side of the paragraph,
Yes.
put the 5th interested party in a position where it was able to proceed with procedural laws to impeach the petitioner, thereby violating that right of equal protection and benefit of the law.
Yes.
At the Senate level, that particular violation was brought to the attention of the Senate.
Yes.
Its lack of consideration, again, we submit, then put the petitioner in a position where she was denied the right to benefit and equal protection of the law.
Yes.
My lord, I go to the second limb as to whether the public participation met the constitutional threshold.
Yes.
From this perspective, we wish to submit from the perspective that one,
yes,
the Assembly's public participation analysis report, from page 1 to the last page, does not, one, show as to whether the participants were read out to the grounds upon which the proposed impeachment proceedings were supposed to proceed on. Two, as to whether the evidence that was in support of those impeachment grounds was laid out before the participants.
Yes.
And number three, as to whether they appreciated the impact. And therefore, as a whole, we submit, because of that failure, the public participation did not meet the constitutional threshold under Article 10 and as laid out by the Supreme Court in the tobacco case. Number two,
that's BAT?
BAT case, yes, sorry. Number two is that the public participation failed to appreciate the uniqueness of the circumstances under which the governor came into office.
Yes.
Which is, and I ask this court to take judicial notice of the fact that Kenya as a whole is a patriarchal society. Number two, that the petitioner came into office through the secret of the ballot that allowed the people of Meru to be able to exercise a decision to elect a candidate on an independent ticket against a highly patriarchal society on the one hand, and number two, a highly political party-based society that is male-dominated.
Yes.
And therefore, the public participation, in its failure to ask itself on how it would allow the members of Meru County who voted for the governor to be able to express their will.
Let me catch up with you speaking, and then you'll have 2 minutes. Yes. Proceed.
And therefore, the failure of the public participation to take into account the uniqueness circumstances under which the people of Meru emancipated themselves from a patriarchal nature of society through a secret ballot to vote into place a female governor, how they would express their wishes either for or against that impeachment proceedings in an open society or in an open manner where those public participations were taking place. The written submissions do not give, or the written analysis of the written memorandums does not give an indication as to whether that was given or taken into consideration. And finally, my Lord, on the question of whether the governor is targeted or all the impeachment proceedings are targeted against her because of her gender, we submit that number one, she is the first elected governor in Meru, women governor. The leadership of Meru County has no other, save for women's representative seats, has no other female elected member of parliament. At the county assembly, we only have 4 elected members of county assembly as of the 2022 general elections. One. 4 is in the previous 2017 general election, 4 members. So the totality of this, my Lord, that I'm putting across is that when you take time to look at those videos that you said, I hope you get an opportunity to look at KMB6. KMB6, where you will see an oathing ceremony of the Churincheke taking into place. Churincheke, that is a male-dominated customary leadership organization in Meru, does not allow women to speak or address it. And number 2, where the political leaders who form the biggest formation within the county assembly of Meru, led by the UDA and the political party known as BAS, were sworn to declare their support for the impeachment motion without consideration as to whether the grounds of impeachment had been qualified. And therefore, on that basis, we submit, my Lord, that the impeachment proceedings, right from the first impeachment proceedings, have been targeted on the governor because of her gender and victory over the patriarchal nature of the society in that county, and perpetuated by male political leaders as well as influencers in Meru County, to the disadvantage and violation of the petitioners' both political rights and procedural rights as regards these particular impeachment proceedings. We submit.
Thank you, Council. So that is the conclusion of highlighting of written submissions for those in support. We will reconvene on Monday, and the session shall be as follows: from 12 noon sharp to 3 p.m. Then we'll take a 30-minute break. Please carry packed lunch so you don't need to leave the premises. Then we'll go from 3:30 until whatever time we conclude. But I hope we'll be able to do 12 to 3 for those opposed. If there's a little bit of spillover, that is understandable. And then a rejoinder limited to only the petitioner for about an hour. Thank you, all of you, particularly Council, various Council. I think today's session is a very good example of the benefit of highlighting of written submissions, and there are two very good examples of where an objection is raised and it is sustained. I really do enjoy hearing highlights in matters like this. So I look forward to seeing you all on Monday. Have a good weekend.
Thank you.